The information made available via this podcast is for informational purposes only and not for the purpose of providing legal advice. You should contact your attorney to obtain advice with respect to any particular issue or problem. Use of and access to this podcast or any of the email links contained within its website do not create an attorney-client relationship between Michael Dockins, Shoemaker, Lupin, Kendrick, and the user or listener. The opinions expressed at or through this podcast are the opinions of the individual author and may not reflect the opinions of the Shoemaker firm or any other attorney.
Are live Wrestling with Law Q&A with Mr. Mike Dockins, Law and Order himself, the Gimmick Attorney. What's up, buddy?
Living the dream, man. Just dealing with current news. There's interesting things happening in wrestling and law right now.
There's a few things that are popping up that we are seeing we will get to tonight. I am your host, Casio, from Rocket 95.1 and Casio's Cut. So it could be the Rock and Doc connection tonight.
There you go.
Like that's the jam. We also have the most recent birthday girl, Miss Ad Free Shows herself, Lauren Yappy.
Gesundheit.
She said she is not working tonight. She's just being blonde and drinking.
That's a full-time job.
Copy that.
Thanks.
Thanks to all our top guys. We got Rob and Horny Beard Guy. Oh, Hornets. We got Anthony Pyers, Ryan, Doug, John, James, Eddie, Sean Jones, Michael, Ken. Amy is logging in. So we have a full crew tonight. So I will get to each and every one of you. If each and every one of you want to ask Mr. Dockins a question, he is our law expert. Our expert. We're going to start with HBG. Hornets Beard Guy is going to be our first question of the night. What's up, buddy?
Hey, what's going on, man? Two quick
in.
questions. Well, thank you.
Yeah, thanks for being here.
This. Yeah, thank you. Two quick questions for you. One, being an attorney, I think your firm has an office here in Charlotte. But
We do.
what kind of questions are you asking you there on that bar exam? It's not like any questions about candy bars or anything, is it?
Oh, well, every state has their own bar. So but I had a buddy who is from Nebraska, and he took a job there for a while. And he also took a job in, I'm trying to remember what state it was, Iowa or somewhere. And they had oil law on there.
Okay.
So the part of the bar exam is everybody takes it. Everybody in the country that takes it takes that portion. And then there's state specific stuff. So I'm actually licensed in Ohio and Indiana because I'm originally from Indiana and I wasn't sure where I was going to go. And they were very, very similar. So most states, it's all the same kind of stuff. So they're asking about contracts and torts and property evidence, civil procedure rules, that sort of thing. But different states, like I imagine Maine and Alaska probably have some maritime law on it. But it's by and large all the same thing. Taking the bar and passing the bar, it's just a game. It really doesn't mean anything about how good of an attorney you're going to be. It's really more of a how well can you take a test in a limited amount of time. So,
all right. And another quick question. You ever run into any of those Saul Goodman types? Any of those guys in these circles? Yeah.
all the time. There's
Can you speak a little bit about that?
Yeah, there was a recent case where there's a music lawyer based out of Hollywood, and they tried to flex that they knew trademark law, and they were just flat out wrong about what it was they were talking about, and they were trying to take down somebody of reasonable importance and the brand that they were using and had been using for some time in wrestling. And what they were doing really was just driving up the cost for themselves and my client, because they were just flat out wrong. And so we finally got to the point, it's like, there's no reason to talk about this anymore. You're wrong, and we'll show that you're wrong, and we'll just do it, handle it in the trademark office, which is really kind of like a court case. It's just administrative. So instead of being up in a court and, having a bailiff and all this, you do it on paper, and then you can have a verbal closing and that sort of thing if you want, months down the road after discovery and all these things. And when the guy finally realized how serious we were, and that we had a client who was willing to pay to fight, he was like, well, I mean, let's get this resolved, because if not, I'm gonna have to use another firm that handles this kind of thing. So after going through all the bullshit and dealing with somebody who didn't know what they were talking about, they finally kind of acknowledged, hey, I don't know what I'm talking about, and I'm gonna have to bring in somebody who does. To which say, well, I wish you had brought them in to begin with because we would have gotten there a lot sooner, but it is what it is. So there's all sorts of just like engineers, just like doctors, just like anybody in any profession. There's good lawyers, there's bad lawyers, and you have to know which is which. And there was a guy who trained me when I was coming up. He was in his late 70s whenever I was a brand new attorney, and he was the spitting image of Orville Redenbacher. But he would tell us, I'd be in his office talking about something and somebody'd call, and he always answered the phone no matter what was going on. If there was a client in the office, whether it was me in the office, no matter what, if the phone rang, he answered it, which I found strange, but I digress. He'd pick up the call and he'd say, hey, you've reached Don, what's going on? And he'd say, let me ask you something. How'd you find me? And they'd say, well, I looked you up in the phone book. And he'd go, oh, I mean, that is the worst thing you could have said to me, because, if you had a tumor in your brain, would you find your brain surgeon from the Yellow Pages? No, of course you wouldn't. You'd get a referral. You'd find somebody. There's a lot of crooked lawyers out there and people who don't know what they're talking about. Lucky for you, you found one who does. And I'm a good lawyer and I'm here to help you, but you should really get a referral to somebody. So, he kind of jumped their shit about it, which made me laugh considering this is a new client or potential client, but he was right? That was the takeaway. Is just like with doctors, you don't want to just pick somebody out of a hat. You need to go to somebody that knows what the hell they're talking about and knows what they're doing, and usually ask around and get a referral and find somebody.
All righty. Well, thanks. Thank you, sir, for taking my questions.
Yeah. Hey, I got a question for you.
Yeah.
You sad to see my boy Cody Zeller go? I realize he's not the greatest NBA player, but
no. Well, actually, yeah. You know what? On a serious note, it was hard to see him and Bismack Biyombo leave, because those guys were like the two longest tenured players on the team. So yeah, going into this 21-22 season, it's going to be difficult to see a bench without Cody Zeller or Bismack on it. But it is what it is. I mean, he's got a 1-year deal over there in Portland, and maybe, who knows? I mean, back. We let Nick Batum go, and he just re-signed with the Clippers. So it seems like as soon as these players leave the Charlotte Hornets, they go into bigger and better things, like with Kemba Walker and
right.
the other guys in the past. So we'll see. I mean, I'm happy. I'm always happy to see the former Charlotte Hornet players do well in other organizations.
Gotcha.
We'll see. Yep.
That's a good fan. I'm not the same way.
Oh, I want to see him fail.
Yeah.
Paul George left the Pacers. I'm like, I hope you break your fucking leg again. I don't want to see you do well. I want you to choke. Oh, playoff P. Let's see it. I'm familiar with it because I watched my team fail in the playoffs while you were the go-to guy. But anyway,
it's like a 6 degrees of separation. If they get a ring, they used to play for the Hornets, so it's like we got a ring. So I don't know.
All right, let's get to our next question. We got our man Anthony Pyers in the house. What's up, buddy? Thanks for joining us.
Hey, thank you so much for having me on the show, Mike. Pleasure to talk to you. How are you?
Hey, I'm well. Thanks for being here.
Good. I have a question on the wrestling related thing. Now, I got my Juris Doctor from NBC, 21 years of Law and Order, 22 years of SVU. So I think I know my legal stuff pretty well. Can you explain to me in layman's terms this Chelsea Green thing? Because I can't figure out how a human being can have their legal name trademarked.
Yep. So anybody can have anything trademarked, including your legal name, right? Because, well, let me start somewhere else. They could not have stopped her from doing anything, right? That's her legal name. You're allowed to go by your legal name. So the only time that it becomes an issue is when it's a famous mark. And without boring you with legal details, when it's a famous mark, it gets treated very differently, and you don't have to go through some of the hoops that normal trademarks go through. But when I talk about a famous mark, I'm talking about McDonald's. I'm talking about Nike, Disney, things like that. I mean, we're talking World Coca-Cola.
Mark.
What's that?
I'm a famous mark.
You are I mean, in Huntsville, you are a famous mark. But to be a famous mark, you get a different level of treatment, right? So if somebody was named, my name was Matt McDonald, and Matt McDonald wanted to start a restaurant and call it McDonald's, he's going to have a problem because McDonald's is a famous mark. But if you've got a not quite as famous mark and it's your last name and you want to open a restaurant and it's your name, you can do that, right? Because it's your legal name. And even if WWE had gone forward with this, and even if they did get a trademark on her name, they can't stop her, right? Because that's her name.
That's what was mostly concerning me.
Yeah, it was. I'm not sure exactly what the hell they were thinking. I think that it was not out of spite, even though that's how I positioned it and how I played it. Because as I talked to Chelsea about it, I'm like, look, this is one of those times where I'm going to tell you, don't keep your mouth closed, because there's going to be a court of public opinion on this, and they're going to look real dumb, and they're going to look like bad guys, and they're not going to want that. And we'll get this resolved, but that's, public campaign against this is going to be fine, and it's going to work out, because they couldn't stop her. They couldn't stop her from doing it. Now, a lot of people, if you want to get like Floyd Mayweather, he's got lots of trademarks on different things. Having it on goods or services, you can do that, right? If he wanted to have Floyd Mayweather for promoting somebody else's goods, right? That's different from boxing. He does have it for boxing, or at least I think he does. But having your legal name as a trademark on goods, you can do that. Anybody can do that, right? And so long as if Amy tried to get Floyd Mayweather and sell T-shirts, he's going to have a problem with that. But it's not necessarily a trademark issue; it's a right of publicity issue. So at that point, he's saying, well, Amy's trying to trade off my name, my goodwill, my fame to make and sell these goods, right? So that's where the issue is. But WWE, they really had no reason to own it anymore. So I don't really think it was out of spite. I think it's such a big company, and the legal team doesn't necessarily know that somebody was released. And particularly, if it was Hulk Hogan or Ric Flair, they're going to know that just because of the name. But Chelsea, no offense, Chelsea isn't Hulk Hogan or Ric Flair, and so they probably didn't know. And something came up in their calendar that they had to do something, and they went ahead and finally did it. And then it made the news, and they looked like idiots. And somebody probably called the legal team and said, what the hell are we doing? Why are we doing this? And they had seen some of the rumblings on Twitter and all that. But the reason I was never worried about it, and I always knew we'd win, is because Chelsea had been going by Chelsea Green for wrestling. So for those services, right? Branding the services. She'd been going by Chelsea Green before she ever went to WWE. So at best, all they could show is that while she was under their umbrella, she was using it for wrestling. So they would have a date of first use of whenever she signed with them. Let's say it's 2018. I don't know the date, but she'd been using it since 16, 15, 14. So she had first use. So when it comes to trademarks, right, first use trumps. And so what would have happened is they filed this consent thing that she signed back in November. That's the way to do it. Signing or not signing these consents is a big issue. And people who follow the trademarks of WWE will notice this happens a lot. And without using names, but I'm sure you guys can figure it out. Not a client of mine, but they refused to sign that consent document, and they got pulled from TV because they wouldn't let WWE protect a trademark in their own name, and they wouldn't sign that consent. There's other people that are still on TV that similarly haven't signed it, and they have to have that consent because it's a living person. But they had it signed by Chelsea. She signed it. They just never filed it. They should have done it 6 months ago, right? No, she signed it in November, so they should have done it 9 months ago. And so they finally did it, but it was after she was released. And there were some people, it might have been one of you, that pointed out, oh, what are they going to do? Make a fake Chelsea Green like they made fake Diesel and fake Razor? Because that works out so well, right? It doesn't work out, and it's silly. But eventually what would have happened, they filed the consent, they would have proven use. So they would provide a specimen to the trademark office, says, hey, trademark office, these wrestling services under the Chelsea Green brand, here's a specimen. Here's, the lower graphics or whatever they would use as the specimen. Let's have a registration. But before it registers, it gets published for opposition. And what that allows is for anybody in the public to say, hey, wait a minute, hold on, trademark office, you screwed up. You shouldn't have allowed this to happen. And here's why. And that's when I was going to step in, and that's when we were going to oppose it and say, look, it's not their mark, first of all, based on the talent agreements. That's neither here nor there. Even if it is their mark, she used it first. So she has prior rights, and the first to use always wins. So you think about the practical side and the legal side. The practical side was they were going to get embarrassed in the public, and they were going to look like bullies. And I don't think they want that, particularly if you are to believe rumors that they're going to sell to somebody at some point. They don't want to be tied up in that and look like fools. But second of all, they were going to lose. And the only way they would have won is to try to bury Chelsea in legal bills. And try to paper her to death, which certainly they could do. And, I warned her of that and said, if they're really going to be spiteful, it could get really expensive. The good news is the firm that they use is way more expensive than we are. So it's going to cost them whatever it costs you. It's going to cost them 2 to 3, 4 times more. But thankfully cooler heads prevailed, and, they abandoned it and moved on. And now Chelsea's will win the day.
Hypothetically, are you helping out this other human being who is having?
Nope. I mean, I would, but no.
Yep, of course. Mike, thanks for taking my time. And of course, this one's for you, Lauren. Go Pats!
Well, I think me and Dockins would join
That's true. Yeah, no doubt about it.
All right, let's go to our next question. Let's keep it rolling. We got our man Eddie P in the house. What's up, buddy?
Hey, Casio. Hi, Mike. Hey, Anthony. Fuck the Patriots, first of all. And Casio, I believe that you and your wife are being railroaded by one Conrad Thompson.
We have many levels to that, but yes, thank you. I'll say yes.
Mike, I got a couple questions. The first one is like some smaller independent wrestling promotions. I have seen where they use like the real music, like from rock bands. And how come they can get away with something like that? They're straight. Do they need to get permission from the bands, or?
So yeah, they get away with it just because they're not on the radar. The way that music rights for almost all bands works is there's clearinghouses that have the publication rights, the publishing rights. There's a couple of them, but ASCAP and BMI are the two big ones. Yeah. And what those places will do is they'll send a person out, or multiple people, employees, and send them, say, hey, go to Toledo and start touring around the restaurants. And they'll go to a restaurant, and they'll go to a bar. And I've seen it in small local bars, not even chains. And they will go in and hear that music's being played because they've got a CD player in the back or whatever. And somebody goes back and starts playing the CD. And next thing you know, they get a cease and desist letter that says, hey, you've been doing this, and you've been doing this without a license. And, we're going to need $10,000 or whatever demand that they make. And you're going to pay this, or we're going to have to sue you because it's copyright infringement. You didn't have the right to play the song publicly like that. And they will always win, and they are not to be trifled with. Right there, it's like Getty Images for pictures. They do the same kind of thing, and they take people down constantly. The good news is they have no interest, and they're not incentivized to actually sue. So anytime they've come at somebody and they've said, well, we're going to sue you, or we want $10,000 for this license, or we're going to sue you, able to go back, kind of assess with the client, like, hey, you're a big bar and you make millions of dollars, and you've got 4 locations in the Toledo area. You're not going to have to pay 10, but you're not going to get away with a couple $100. Or, hey, this is a small nonprofit, or this is a small whatever. They don't make a lot of money, so you're really barking up a tree that they'll just go bankrupt, and then you get nothing. So we'll offer you $500. We'll offer you $1,000, and they almost always take it. Almost always. If not, they push back and ask for a little bit more. But never have I had anybody sued.
Yeah, I know some bands are really hard to deal with, like especially Metallica. Make that specifically. Lars Ulrich has made a big case over music rights over the years.
Right.
And my second question is, would our dear friend Arn Anderson have a leg to stand for if he sued Conrad Thompson for slander? When he put the good name of Arn Anderson's in the same sentence as Van freaking Hammer?
Yeah, that's a funny question. Slander, people like to throw around slander and defamation and libel and these sorts of things. It is not.
They sling defecation around.
Yeah, the monkeys do anyway. They try, but it's a very, very difficult thing to prove, right?
Yeah, but it's easy to. If you're being compared to Van Hammer, that's at least pain and suffering right there alone.
Yeah, I wish that we could get pain and suffering for people as often as people would like. That's also not an easy thing to get. The thing about defamation is you have to prove damage, right? So did it really hurt the Arn brand? I know this is a silly question, but this is the real answer. It's you have to prove damages, right? So his first thing would be proving damage. Now, the other thing is, if Conrad thinks that Arn is as talented or less talented than Van Hammer, that's an opinion, and people are entitled to their opinions. Now, it's a little different when you say, in my opinion, Arn Anderson has herpes and he's spreading it around everybody. That's different. That's a different kind of defamation, and that opinion doesn't get you covered, right? That'll get you in trouble. There's something called defamation per se. And so if you go around spreading rumors about somebody, about slut shaming isn't one. I wouldn't be surprised if they start to treat it that way. But, people having a communicable disease and this sort of thing, where the court will say, we don't even have to find that there were actual damages. You were damaged. By virtue of somebody saying you've got an STD, you've got a mental illness, you've got all these things, you'll win that. It's easier to win because you don't have to prove damages.
Thank you for taking my questions, Mike.
For sure. Thanks for being here.
You have a good evening.
You too.
So I could technically say Mike Dockins has herpes per se. And that covers me, correct? That's all I got.
No.
Oh, I thought if I said per se, I got away with it.
No.
Okay.
That's just defamation per se for the courts.
Oh, okay. Let's go to our next question. Doug McLeod in the house. What's up, Doug?
Not much. Just watching up here in Alaska. So my question is regarding all of these releases and this 30 or 90-day window. There seems to be a lot of discussion over whether it's an actual non-compete or not. So my question is, are these actually non-complete causes, or is it more like a severance package where for whatever period of time they're getting paid for, they can't seek employment with another company?
Yep. It's actually, I mean, technically it is a non-compete, right? Because it's part of their contract, but it's not actually a release plus a non-compete. WWE is required by their own contracts to give you 90-day notice if they're going to release you from your contract before it's up, right? So what they'll say is, hey, in 90 days, sorry about it, you're shit canned. So they are still under contract for that 90 days. Part of the contract, of course, is the non-compete. So it's already part of something you've signed and whatever. So they have to pay you because it's part of the contract, right? Okay. You're still technically a talent under contract. And if they wanted to, they could have you go out and wrestle under those 90 days. Now, of course, they won't and don't, because they don't want to help build your brand and then have you go to Nitro next week, right? You think back to the 90s where they did kind of do that kind of thing and roll people out to the end, or they would have people on house shows. They don't even do that so much anymore. It's just, hey, you've got this downside guarantee. We'll pay you your downside guarantee. Go home. Goodbye. And so it's not a severance. It's just the contract. It just is what it is. Now, there are people who do ask for a release, right? And they can say, no, I'm not going to do that. And they have granted some people a release, let them out of their contract early. Usually that then will have a release statement, right? Something that everybody signs because it's a premature release, not a, hey, we're just not keeping you anymore. And those will have whatever they have, 30 days, 90 days, 6 months, whatever they want to put in there.
So what WWE Chelsea got out a week early so that she could appear on the.
I think that's right. They as much as I like to rake them over the coals sometimes because they are the big bad monster, they are actually a pretty decent company, and they are actually, and I should say they can be caring and can be real people. And they've done good things that they don't get credit for. So when I shit on them, it's almost in jest. They do some good things and do things the right way sometimes, just not always. The thing about their contracts that people have to be wary of, and that I've advised plenty of clients about, was, look, don't get fired. I'm going to put up a pro wrestling tees store and sell my own shirts because I don't like the royalty deal I got, or they're not making a t-shirt for me. You can do that. They might not care. They might not fire you. But if they do fire you, and they fire you for cause, so not just, hey, we're letting you go from your contract, but you've done something bad, something you shouldn't have done. You have breached the contract, and we fire you. It starts a 1-year non-compete. So you're on the sideline for a year. So the pro wrestling tees store ain't worth it. And I've had clients that were like, whoa, I didn't realize that could happen. Yeah, I'm pulling my store down. And I'm like, that's a smart move. I don't think the $400 a month or whatever they were getting is worth being on the sidelines for a year. That cover it?
Yep, that covers it. Thank you very much.
For sure.
All right, we are coming up. I forgot. Oh, Michael Mack, where you at, brother?
I'm right here, Casio. Thank you so much for getting my question in. And Mike, always nice to talk to you. Thank you for doing this.
Yeah, man.
I have two kind of separate questions, and they're both a little bit different, but they're both kind of short. The first question is, being a lawyer, are you a fan of John Grisham? And if so, what are some of your favorite John Grisham novels? Because I'm a big fan of his. My second question deals with AEW and the fact that over the past year, Tony Khan has shown that he is more willing than, say, WWE to shell out money for certain songs, such as John Moxley's been using Wild Thing. And what are your thoughts on AEW's willingness to purchase songs or to purchase the rights to certain music? And do you see any potential pitfalls with that?
So let me start with the other one first. I don't have near the amount of time to read that I used to with work and, doing this kind of stuff and having kids that are older and getting involved in stuff. So I don't get a chance to read very much. But when I did, I didn't read a lot of Grisham, not because he's not a great writer and tells great stories. Certainly he does and is, but that's my day job, right? And so as interesting as it is, I don't want to hear about that kind of stuff. I need to get away from it. I did used to read a lot of Brad Meltzer, not to be confused with Dave, who did a lot of like conspiracy stuff and kind of historical. Think like, what was the movie with Tom Hanks? Da Vinci Code type stuff. No. I'm thinking about Nick Cage, Nicolas Cage,
National
and
Treasure.
Yes, yeah. National Treasure, stuff like that. It's kind of historical based. I enjoyed Meltzer. Again, Brad, not Dave, and thought it was great. And so I used to read a lot of Brad Meltzer, but again, I don't have much time to read anymore. As for the AEW question, I think it's awesome. I think it's an unnecessary expense, quite frankly, but a lot of the musicians are seeing there's value in having this song that maybe has kind of fallen to the wayside or wasn't as popular. Now it's being licensed, it's being heard on national TV by 1 million plus people every week and in pay-per-views to however many people buy those. So there is value in it. But it to me, it's an unnecessary expense. Funny story about Moxley, the exploding barbed wire match that was what it was. That weekend I was in town to meet with a number of clients and hang out and go to the show, of course. And John texted me and was like, "Hey, I'm trying to get this song as the entrance because it was an homage, right, to the original death match, exploding barbed wire." And AEW can't seem to get a license. They can't track anybody down. They can't get to the right people. Do you know anything about this? Can you help me? Yep. And so I got a hold of the band manager actually, and tried working with the band manager and went through the details. And he's like, "Yeah, I'm all for this. I would love for it, but I'm not in charge of publication. We got to get you to the publisher." So like I mentioned, ASCAP and BMI. For them, I think it was Sony. It was the Sony Music Group. And so he tried to put me in touch with the people there. And because it was a weekend, they didn't get to me in time. So he wasn't able to get the song, which what irritates me most about that is I had actually put off a call from the week earlier until the week after I got back from that show. That was some litigation involving a bunch of different music publishers, including Sony. So if I had taken that call the week earlier, I would have had a direct contact to the owner of the license and I could have called him that weekend. But I wasn't able to get it for him, but we managed to get him in touch and reach out to the right people. And then I put him in touch with, and AEW was trying to do it too, with the right people so that they got the license next time he had a death match.
That's awesome. Thank you so much for answering those questions.
Yeah, for sure.
Have a nice rest of your evening.
Thanks, you too.
Thanks, Michael. Let's go to our next question. Rocking right along. Amy Vaughn in the house. Amy?
Hi, guys. How are you all?
Hi. We're doing great. What you got for Mike Doc?
Actually, it's kind of for both of you all since we don't have any more episodes of Sad News Bears. I was wondering if you all had any neat collectibles or memorabilia lately that you've picked up.
Ooh. The answer is yes. The next question would be to figure out what to grab. I see Dockins looking around. All I have in reach is somebody sent me my lookalike, the Otis pop figure. That's the only thing close, but I'll grab something before the end of the show.
Okay.
That's a deal.
I think it's, well, I don't know. Casio, have we decided a Sad News Bear's dead? I don't think it is. We just have been
not
on
officially,
hiatus.
no.
An extended hiatus.
I think the bear has been in a coma.
Yeah. Down for the winter.
We're hibernation.
Summer. Yeah, hibernation. There you go.
We're reverse. We're fat bears, so we hibernate in the summer. Too hot for us.
Too hot for you.
So I've got all kinds of Andre the Giant stuff, which is well known. My love and affection for Andre. Nothing's within reach. But High Spots did a grab bag thing where it was like you pay for a spot and you pick a number, and if they pull your number, you get something cool of equal value. It was $100, and it's something of that value, right? And so I got 2 numbers because the grand prize was a signed Andre thing, and I don't have anything signed by him yet. I got down to the final 3, the numbers I picked, and I was third. I'm like, son of a bitch. So I didn't get it, but what I ended up getting, Oh, I thought it was within reach. It's not. It was a couple of signed Hardy Boys figures.
Oh, cool.
But-
did you find out who won and contact them to see what their price might
Like
be?
the way Amy think.
I did. As soon as it was over, I hit him up, and they had said what the value was, and I offered him more than the value. And he was like, well, the whole reason that I did this was because, he's the reason I got into wrestling and whatever. And I'm like, okay. I said, well, I think there's nothing secretive about this, but Conrad owns some cowboy boots of Andre the Giant's.
Mm-hmm.
They're usually in his background for when he's doing stuff. And so I didn't talk to Conrad about this, but I think he would have been okay with it. I was like, well, I'll offer you a little more money, and I have access to some of his actual worn boots. I'm sure that I could get those, and you could take pictures with them, and whatever. Because the guy was not far from
Per se,
yes, not far from where I live. I'm like, I can drive to you. I pay cash, and he wasn't having it. And I was like, all right, well, if you ever change your mind, let me know.
Darn.
turned down cash and an experience. That was. Ooh.
And I offered him about 40% higher than what their stated value was.
He knows you're good for it. He knows you're a big fan. He's waiting.
Yeah. He's
like with the Ric Flair robe that we watched. He's going to hold you up for more money.
That guy might secretly take a tire iron to the leg at some point with those moves. That was some shenanigans.
I was going to say.
He knows you're a famous mark for Andre. So you're in. He's got you taken care of.
I do too. And Casio, I don't think it was you either in the poop gate or whatever. I think it's Tony, actually. I think someone I think he acts way too concerned about you and Dave and, listening to the show. He's like taking it all in. I think he's the one who did it, actually. That's my guess.
Okay. I like these curveballs coming. I like predictions. Maybe we'll take a prediction of who pooped. And that'll give Dockins time to go grab something of memorabilia before the end of the show.
Okay. Well, and thank you all for doing this. This is really fun. I like listening to the legal aspects, kind of the peek behind the curtain in a sense. So we thank you, Mike, for coming on.
Oh, for sure.
Us.
It's fun. It's always an adventure. I can say that much.
All right. Thanks.
All right. Let's go. Who we got next? Let's go to John. John, you there, brother?
Yes, sir. I'm here. How y'all doing?
Good, man. Thanks for joining us, brother.
Good. Hey, it's perfect transition because I was wanting to know how the defamation lawsuit is going on the Who Done It. Has Mike still representing Dave Silva, or did after the awkward conversation between you, Casio, and your former best friend Conrad on the air, giving out your government name and giving out your wife's government name, did Mike drop Dave to represent you?
I am not officially represented by Dockins. I mean, if he realizes he's on the losing side and wants to jump ship, I'll be glad to take him. I think Shuley tarnished my name more than help it. So I am looking for new representation.
I'm just waiting for Casio to take the bullet for his wife. She did it.
Oh no, buddy. If my wife shit in that bathroom, she'd be on the show. We'd be on my podcast talking about
it's definitely been interesting. I want to give the sentiments of others. We do miss Sad News Bears. Understand the reason for the hiatus, and when you guys are able to get back, great. But sure, do loving the WHW with the Who Done It, and the excitement that is happening.
Is he selling shirts with Who Done It on it yet?
I don't know.
That's a good question.
Because I need to get first.
He does, and I own one.
Oh, damn it! He got first use. I needed to be part of that.
I guess my real question is going to be: did the Monday Night Wars end because of the lawsuits that did Vince McMahon just sue Turner enough to where they watered down their product? That was really what ended the whole Monday Night Wars, Mike?
Yeah, I don't think so. The lawsuits, it was mostly petty stuff. I mean, it was real. None of it was made up. But you've probably heard Eric talk about it on his show that Turner was very litigation averse, right? And so when somebody came to him was like, "Oh, I hurt my back. I did this because my agent forced me to do it." And if they weren't asking for more than the number, I think it was like 100 grand, 125 grand, something like that. If they weren't asking for more than that, they'd just pay him and, send them on their way. And so Turner, I'm sure, was coming down on Eric and everybody else about, hey, stop towing that line, stop pushing, poking the bear, because we're not going to spend the money. They could afford it. They had, at that point, they had more money than Vince. But it was all valid stuff. And some of it was out of spite. Certainly when they were getting their asses kicked for those 83 weeks, and you've got Razor Ramon out there, Scott Hall acting like Razor Ramon. That's a problem, right? Because the WWE contracts, I assume back then, like they do now, defines intellectual property as everything under the sun. So we're talking about hand gestures, mannerisms, catchphrases, voice affects, all these sorts of things are covered as intellectual property. So when somebody goes somewhere else and starts acting like that, that becomes a problem. So they were right to have that lawsuit. They were wrong in that Scott Hall had been doing some of that stuff since the AWA. I think Eric's pointed that out, that if the Turner legal team had looked it up and looked into it, they could have pushed back and said, no, he's free to do this because he was doing it before he went to WWE. And that was before intellectual property was really like the buzz in wrestling. That's before WWE was public. And so being public and potentially selling off and all of that, you will have assets, right? And you want to list assets that you have that the company is backed. Well, intellectual property is an asset. If you have a trademark registration, if you have copyright registrations, if you have patents, that's all stuff that becomes an asset of the company. Back when it was actual territory days, right? 80s, early 90s, kind of mid 90s, these guys, the wrestlers themselves owned the IP. And so it was theirs to do with as they pleased, and they could hop around and be Jerry the King Lawler anywhere he wanted to be because that was his intellectual property. That's when, you've heard Bruce talk about it, WWE started saying, wait a minute, we're using somebody else's brand who can then leave, build them up, get them on national TV, get them way more famous than they've ever been before, and they can bail. And they can go down to Turner and whatever. So that's why we're going to rename them. That's why we're going to create our own IP that we will own. So that if they become famous, they become famous under our name, not somebody else's. And we can continue to monetize that even after they're gone. If they become the Andre the Giants and Macho Man or whatever of the world, the brand gets to be so famous that even after they're gone or even after they die, they can still sell stuff and make money on it. But the lawsuits from WCW or from WWE, WCW, I don't think that had a huge effect on whether or not they were going to go under. I think Eric is probably right in that a lot of it was the acquisition by AOL. They didn't want wrestling. And so then you've got nobody backing you. They're on paper dumping the debt on your side of the ledger. You don't have the ability to sign the people that you want to sign or spend the money that you want to spend. And so everything just went to hell in a handbasket. That was part of it, but I think it's a minor part of it.
Okay. Yeah. I was just curious because reading the Nitro book, they were talking about, Vince would put it out there in the papers. He'd write letters about, the violence, everything that's happening. And it felt like they were trying to fight on all fronts. And Turner just kind of had incompetent attorneys that they didn't want, they weren't going to fight for little WCW and, things, lawsuits and losses, follow suit. And then it's, too much liability. We need to, standards and practices. It's, once you get found guilty on something, you just get, they just start trying to railroad you the rest of the way.
I mean, it's certainly part of it. I don't know that their attorneys were incompetent. I think they didn't have an understanding of wrestling, and they also knew they weren't going to fight. As for Vince putting stuff out in dirt sheets in the news, that kind of goes back to my earlier point about Chelsea. Control the narrative. And so you've got the court of public opinion and you've got the legal court. So if you're out there and you're pitching this story that, they're stealing your IP and they're doing all these things and they're not going to fight back, you win, right? You controlled the narrative. The victor gets to write history, as they say. So that's kind of what it was. It doesn't mean that they were right, but he was playing it smart. Get the public on your side and then take them to court and hammer them because they're not going to fight it anyway.
I sure do appreciate the time.
Yeah, for sure. Thanks for being here.
Follow up, Dawkins. Amy wants to know, is it possible that WWE didn't realize that Chelsea Green was her legal name?
No, they had to have, because the consent document that they filed Friday or whatever day that was, it is signed Chelsea Ann Green. Like, it has her legal name on it. It's a consent that says, I, Jonathan Good, consent to the registration of my wrestling name, John Moxley or Mox or, whatever. And then you sign it, he signs that document, Jonathan Good. So it has your legal name on there. So they knew it. They knew what they were doing. I think the legal team didn't appreciate that she had been released. They just didn't know. I doubt they're even wrestling fans.
I thought maybe that could possibly be why it started. Like, they didn't even realize that was her real name as she's using it. And then once they got started, it was like, well, I guess we need to see it through. I don't know. I just thought that I could see that happening. Like you said, they're not wrestling fans and they may not have known she had been released. And so then it's kind of like, do you not even know that's her real name? So yeah. I don't know. That's just a thing that popped in.
No, it's a good thought, but at least on that document that they just filed, it has her legal name. It has to have her legal name. So they knew.
All right, let's knock out our next question. T-Rob, 1977. What's up, Travis?
Hey. Yeah, that's like job application line 1, isn't it? Name, first,
last. Right. It's certainly under contract. It's in all the documents that they handle.
So I was thinking, with all this talk that people are going here, there, and everywhere, and people even like being raised from the dead that are supposedly the best in the world, Adam Shear, or Sure, however you say it, seems to be flying under the radar. Have you heard any buzz about him, or can you not say anything about that here?
If I had heard something, I couldn't tell you, but I have not heard anything, to be 100% transparent, not anything at all. My guess is with him, I've heard from a number of people, he can be difficult to work with. I don't know if that's true or not, right? I haven't the foggiest idea. But if that reputation precedes him a little bit, that's probably a little bit of a problem. But he made a significant amount of money in the last couple of years. So if I were him, I'd take some time off, right? Rest the body and go do something that you love before jumping back into it. He also did a lot of mouth running early on in the pandemic about if I get let go, WWE is the only place I'll ever work. I'll never work anywhere else. And, if you don't like it, go get a job at Domino's or whatever he said. He was insulting people about COVID and their jobs and, working 9 to 5s and this sort of thing. So it probably will do him some good to tuck away and not be seen for a little bit and then hop back into it.
Well, he is a monster, so I could see that's why he's hard to deal with. I didn't know that about him personally, though. That's sad. I kind of liked him. We had seen him on a house show in Oklahoma City, and he was pretty personable with everybody. I the math just really lined up with All Out. I was really hoping that he would pop up, and then these other names surface. So maybe that's not in the cards, but
sure, cool. At the same time, some people, a lot of surprises and things I have been privy to and have known before they were announced. But somebody like Sting and things like that, that was under pretty tight wraps. Even people that were there didn't know. Like, they had a blacked out SUV pick him up from the airport, and it was under very close supervision. He got tucked away into a bus that nobody had access to. Like, nobody knew he was there. So they can, while there are some leaks, they can keep things locked down pretty tightly. So that could be the case with them.
Sting didn't talk for over a year, so he can keep his mouth shut.
Yeah.
All right, Dockins. Hopefully we'll see you in Chicago, right?
I'm planning on being there.
Excellent. I enjoy listening to you in my ears. I have to work at night 3 nights a week, so I like hearing what you have to say.
I've got some in here somewhere. I had one of our summer people do a bunch of research on a bunch of different cases and things that will keep me from the delay, because I'm not Conrad. I don't have a research team do it for me, and then I just got to familiarize myself with the notes. I do the research myself, so it ends up being a pretty expansive effort to do a show. But the hard part's out of the way now.
Just tell the big fella you need a paralegal. Say, hey, these are my demands, sir. It's in my contract, and he'll just believe you.
All right, when the lawyer makes demands on the client, that's pretty strong.
Yeah.
These are my terms.
Strong.
All right, let's go to Miss Ad Free Shows. we have a question for you. One, what are you drinking?
Me?
Yeah.
Well, Cassie, what are you drinking, honey?
Oh, just water.
Oh, well, who invited you? Every party needs a pooper. Mike Dockins, what are you drinking?
Monster and
Monster.
vodka.
Oh, that shit'll kill you. I'm drinking.
That's the hope. Long day, and I just got back from working out, so I needed a little extra juice for this.
Okay, watch your toes. He's dropping weight.
Oh, Jesus Christ!
I'm having a little wine tonight.
All right.
How it goes. It's only Monday. So you talked in an early episode about the Midnight in the Garden of Good and Evil and that movie poster.
Mm-hmm.
And now I've heard something about Randy Orton. Fill me in. Tell me about this.
So the stuff with Randy is he's got his tribal tattoo right before he was all sleeved up. That was the big tattoo that he had that everybody noticed. And you might remember a couple years ago for The Hangover, I think it was Hangover 2, maybe. Mike Tyson's face tattoo made it on there, but then Ed Helms got it too. Spoiler alert from 12 years ago, but he got the face tattoo as well when they were in Bangkok or wherever they were. Well, when you talk about a tattoo, it's artwork, right? It's just artwork that is on a canvas that is flesh instead of on, actual canvas. And so the tattoo artist registered the copyright. They registered the artwork. So I could grab a piece of paper right now, scrawl a bunch of stuff on it, call it art, and I could register that. And I have a registered copyright and I own that IP. And so if somebody were to copy that, and I show it to you guys, right? And one of you guys takes it and tries to make t-shirts off of it, that's my copyright. So I can sue you for it. Well, that's basically what the tattoo artist said and did. That was their artwork. They had created that tribal tattoo. They had drawn it out and they protected it and they registered it. And then, Randy Orton's on TV. And there's probably nothing they could do about that, right? You've got a license. You don't have to cover up your tattoo because it's on your skin and somebody else owns the art. But what the WWE did and what Y2K and all these other people did is they created derivative works. So under the copyright law, you get a bundle of rights, it's called, and you can license out any of those separate rights. But so part of those bundle of rights, one is derivative works. A derivative work is a new artistic work that is based on some sort of parent work. So think about Star Wars, the movie, right? That's the parent work. A derivative would be any action figures or comic books or novelizations or t-shirts or posters or anything that Star Wars has made. Those are all derivative works based on the original copyright. So with the tattoo and with Randy Orton, you have action figures and you have it being reproduced on a video game. So those are derivative works of Randy's skin, of the artwork from the TV show. So what the artist was saying is, hey, you use this without my authority. And Randy didn't have the authority to give you permission to do that because he's not the copyright holder. He doesn't own it. And so WWE tried to pay off the copyright owner $450 to go away. And it probably cost, 5, 10, 12 grand just to prepare the complaint and file it. So obviously they're not going away for $450. I think it was filed in 2018. And so now we're in 2021. It got pushed back because of COVID. But it's finally going to happen. And they've got a pre-trial hearing coming up soon, which is everybody gets together and the judge kind of goes through, this is how we're going to play this. This is the groundworks and whatever. And let's fight it out. Let's see what everybody's got to say. So I think WWE's defenses was a couple fold. One was it was de minimis, which is to say there's really no value. It's, just part of many tattoos that he has and it's small and, who cares? One was the kind of implied license by virtue of being on his skin and him being a celebrity and all these things that they had a license to do that. I don't remember. Oh, the third one was there's no damages. She's not damaged in any way. Bad news for them is with copyright, you don't have to prove actual damages. With copyright, if you've got a registration and you have to have a registration to sue, if you have a registration, you did it in a timely fashion, you get what's called statutory damages, which is to say she can go to court and say, I want actual damages or statutory damages. So that is, judge, you get to decide that if infringement was found, they have to pay. And they have to pay between $750 and $35,000 per work infringed. Now, how that gets calculated differs from place to place, but some people would say that every video game that was issued, every download that was issued is its own separate $750 to $35,000. So if you think that it sold 20,000 of course it was more than that, but if they sold 20,000 copies, well, that's 20,000 times 35,000 is their maximum exposure. So she didn't have to prove actual damages. She can ask for statutory damages. That's why statutory damages exist. If there's some small artist, some small musician who's got some great hook that Jay-Z decides to use, Casio put that up on a Facebook thing recently, the Middle Eastern guy, I don't remember where he's from, but Middle Eastern guy, and Jay-Z used it from Big Pimpin', right? It's a hell of a hook. But it's some small artist that nobody knows about. And you got to say, well, I've got actual damages. Well, how many CDs do you usually sell? Well, about 1,000 a year. Well, where are the real damages? There aren't any. So you've got statutory damages to elect it, because then you can smack around the infringer and say, well, you're going to pay 35,000 times the 1,000 copies they would normally sell, plus attorney's fees. So that is the very long answer for what's going on. It's a copyright infringement sort of thing. She has, and frankly, I don't know that she's wrong. I think it'll get resolved and dealt with out of court. But WWE will fight this for sure. If they can't resolve it, they will take it to the end, because they can't afford to lose this. Because if they lose it, that will apply to every tattoo artist. And what it'll result in is they will forbid anybody from getting new tattoos unless and until they get a release and get permission to do that kind of stuff.
That's crazy. Okay, I have another question. Try to be more brief on this one so we can get everybody. Were you friends with Conrad Thompson before he became your client? How did that work out?
Nope. Not at all. I was a fan and listened to the podcasts, and I've talked about it before in different places, maybe on my show, I don't know, but I have been a wrestling fan since I was a kid. I've always enjoyed it and continued to watch it, and kind of fell out of it and back into it and out of it and back into it. And I didn't really have any wrestling friends here locally, but I would record Raw and watch it or whatever. And like I said, I listened to all the podcasts, and I knew they had done Starcast, and I was laying on the couch one night, fast forwarding through Raw, and thought, I wonder if that Conrad guy ever protected the Starcast brand. So I looked it up and found that he didn't. So I'm like, boy, wouldn't this be cool if I could get in touch with him and land him as a client? Because I had started doing some stuff locally and regionally, trying to just throw as much at the wall to see what would stick, because I knew that I could help wrestlers, and having a background and being passionate about it would show whenever I talked to them, and they would understand that and appreciate that. And I have a genuine care and affection for him and wanted to help. Of course, it's part of my job and I get paid for it, don't get me wrong, but I do plenty of things that I don't bill for and that I don't get paid for, because I want good things to happen to these people who throw their bodies on the line for our entertainment. And so I remember talking to my wife about, I'm going to throw all this stuff at the wall, but and my exact words were, I'm going to shoot for the moon and reach out to this Conrad guy who does the podcast, because if I can get in with him, he can open a lot of doors for me, and that'll be it. It'll just go crazy from there. So I reached out to him that night when I was laying on the couch, fast forwarding through Raw, and he hit me back it was on Twitter. It was just a DM, right? He keeps his DMs open. And I heard back from him within like 30 seconds, and my jaw dropped, and I was like, oh my gosh. And he said something like, hey man, thanks for reaching out. I actually got some numbers from a local guy. I'd be interested to hear what you have to say. So what's a good email for you? I'll send you a proposal tomorrow. So he gave me his email. The next morning I got up early, got into work, looked at all the podcasts, looked at all the options, laid out a proposal to him, and sent it to him. He said, this is great. I'll be in touch. And I didn't hear from him for weeks. And so I sent him another email. I'm like, I know you're busy. I'm just going to be the squeaky wheel. I'm going to keep sending this to you to trickle it back to the top of your inbox until you tell me not to. And if you tell me not to, and you want to go in the other direction, go for it. But I'm going to keep being the squeaky wheel until I hear from you. So I did that for months and months and months. And then finally, as he was starting to do Starcast 2 planning, he called me one day, and that was it. The rest was history. Within a week, I was in touch with the Good Brothers and had landed them as a client. And then after Starcast, landed a whole bunch of people, and it's just spiraled from there. And now Conrad's one of my best friends. So it worked out.
So it did. Thank you.
Thanks for being here.
Duh.
Oh, that was so sweet. That was such a good story. No, so it is a super cool story. All right, we got a few more. I want to make sure we get everybody. Plus Lindsay in the house. She wanted a question for Dockins.
Hi.
Hey,
I'm
hey.
sorry I'm a little late to the party, so I have no idea if the question was asked, but like I probably have 50 questions I could ask you, but goodness. I really just want to know what the process is like, either for WWE or AEW. Like, what's the hiring process like? Is there orientation? Like, how do they determine what kind of contracts to give people? Things like that.
Yep. So WWE, despite what they try to say, there really isn't a process. They go to you and they say, "Here's the contract, take it or leave it." There's been a lot of debate, and they like to hang their hat on in lawsuits when people have challenged their status as contractors, because for all intents and purposes, and if you look at the tax law, and there's a 21 question sort of thing that the IRS looks at, and the IRS has said explicitly in their regulations, I've researched it, I've read it, it says, regardless of what you call yourself, if you call yourself an independent contractor, great. If you call yourself an employee, that's cool too. But really, we're going to look at what's happening in real life. And so here's these 20 questions, and I went through it, and I did it in my head as objectively as I could in the light most favorable to WWE. And I came down to 17 of the 20 were in favor of employee and 3 were in favor of independent contractor. But what WWE likes to argue in their court cases is, hey, this was a freely and fully negotiated contract by these talents, and they admitted that's part of the contract that says I am an independent contractor. They acknowledge that they are an independent contractor, so they can't be heard to complain about it and say something different now. Bullshit, because it's not freely negotiated. What they will negotiate is coach versus first class, whether or not you get a car, the dollars, maybe the dates. But it all depends on where in the pecking order you are, right? If you're a low person, you have no say. You'll sign it or find another job. If you're AJ Styles, if you're Hulk Hogan, if you're Stone Cold Steve Austin, that's a whole different world, and they get away with more and push back. They will not allow you to push back on intellectual property, and they won't allow you to push back on employee versus contractor. AEW is very different. They have different tiers, and I don't fully understand the difference between all the tiers. They've got like a tier 0, and that's a person who's like an extra, right? So it's a one-time sort of, it's a quick and dirty, hey, you're going to be on here, you're going to play the trumpet and run around the ring real quick, and you're going to get $500, and that's it. And then there's like another tier step up where it's, hey, you're going to get paid on a per appearance basis. So we don't know how many dates we're going to use you, but we're going to use you more than once. And you're going to get paid whatever, $1,000, $5,000 for every appearance. And then you get stepped up into kind of independent contractor, but employee status, where you're going to get a certain amount guaranteed, and you're going to get that for the year. So, and from there, the higher tiers, you might have an employee basis, where you're going to be an employee on one side. So have kind of an employment contract and get insurance and that sort of thing. But you also have a talent contract, like think Triple H and Stephanie, where they had an employment contract where they were employees, but they also had talent contracts and got paid differently. They all have something that resembles an orientation. They have policies and things like that they make you familiar with. A lot of times that's part of the contract in some way. We can fire you if you go out and you do something to disparage the company or do something to embarrass the company. You can't do drugs. You're responsible for your own fitness, this sort of thing. But at least WWE treats it more like a company, an employee, right? So there is some sort of training and things that happen. AEW is too. I know AEW's legal team really, really well. I enjoy them as people. They're good and easy to deal with, and we have a good rapport. So even though we sit on the opposite side of the table for a lot of things, in some regards, we're on the same side of the table. Like I feel as myself that I'm kind of team AEW. I will represent my client and I will get them as much money as I can, or get them the best deal that I can, but it's done in a very polite and friendly sort of manner. Versus WWE, it's almost always confrontational. It's just this all the time. But it's a different monster, right? It's a multinational, multi-billion-dollar publicly traded company. But there's a little bit of that. The process is usually pretty easy for both. WWE, it's because, I'm not gonna be able to negotiate anything. I know the few things I can, so I can help you with that. AEW, it's similar. There's a number of things that can't be negotiated, and you're not going to get a higher royalty rate than the highest royalty rate that they have for, the Stings of the world. And so even if you're a very famous wrestler that just came over from WWE, we're not going to give you a higher cut than Sting gets, or than, the Bucks get and their EVPs or whoever. But again, they're easy to deal with. They're super friendly, and they genuinely care about their wrestlers.
That's good. I guess feeding off of that too, because I know that WWE kind of has like different types of contracts for people. I'm always curious because I know that they have like legends. I don't know if that's like a contract, or can you make appearances during, like, when you have a legends contract, things like that.
There is a legends contract, and they're all over the map. sometimes it's just kind of a placeholder. You're not going to go work for another company and, do whatever, but they'll still let them do really small indies. It's more tied to television. You're not going to appear on TV for somebody else. But you can go do, the WBW wrestling was one in Toledo here. You can go do that and make an appearance. That's fine. They're not on TV or they're only on, local access. But some of them, you saw Ric Flair just got released from his Legends deal. That's different. Sometimes it's kind of legend plus ambassador. So they have him going out doing very regular things representing the company versus, hey, come to Access. Really, it's kind of what it boils down to is we'll fly you out, do Access for WrestleMania, and we'll give you this menial amount of money during the year. We'll pay you for access and put you up places and things like that. But that's a separate contract. It's not really a talent agreement. It's a little less restrictive, probably a lot less restrictive than a talent agreement, but you're not in the ring. So it doesn't have to say much. They're short.
Gotcha. Yeah, I could probably pick your brain all day, but I'll give other people an opportunity.
Well, I do. I try to for the show. Do ask me anything. So feel free to chime in.
Yeah, definitely. Thank you for answering me.
Yeah, of course. Matt, you're muted.
Thank you, Lindsay. Let's go to AJ in the house. Thanks for being patient, brother.
Oh, no problem. Worth the time. We get so much knowledge here tonight, so I'm willing to take it all in.
What's going on, man?
Hey, not much. My question, it's kind of a two-parter. First one is talking about royalties. I know with wrestling, it's a little different how they do it, but I think probably with their contracts now, like, hey, just because you leave the company, we own your rights to your previous commentary and all that stuff like that. Do you ever see that being a change where they can actually get that? Because, you see sometimes like the movies and actors and stuff, they can get residuals from shows they've been in, they get shown. I know it's been a little bit talked about, like with the streaming, I guess maybe how the contracts worded. Because my second question was like, if you just had any thoughts maybe on like the whole Disney situation that we're seeing now with Black Widow, how that, with streaming versus being in person at the theater. So I just kind of want to pick your brain on those if you could.
Yeah. So I'll start with that first, the streaming side of things. It's all going to depend on what the contract says and, the interpretation of the contract. And a contract like that for somebody like Scarlett Johansson is, I imagine it's 20, 30, 40 pages long. And so you can call something, a theater release, but that could be defined any number of ways. And you can define it however you want. I could say that a theater release is shown in a church, for some people before it's ever released. It's just all about the definition. I don't believe that they would bring a lawsuit if that were truly the definition. So it almost seems like Disney's going to kind of rely on that streaming, particularly in a pandemic, is a natural extension of a theater release, and it's kind of the progressive step, and so it's included. I think they'll lose that, particularly in view of the Bill Nye case that came down where they basically found I guess in Bill Nye they did find that it was kind of natural progression. Basically they said streaming is the next natural progression to DVDs. People don't really do DVDs anymore, but it's video on demand is essentially the same thing as a DVD. And so Bill Nye didn't get extra residuals and things like that. But for this, that's a little different, right? It's not quite a streaming equivalent to going to a movie theater. Going to a movie theater is a very different thing. So it'll be interesting to see where the courts come down. But of course, Disney and, the Universal and everybody and their brother does not want to see that get lost, right? They did not want to see Disney lose. And Disney's Disney for a reason. So they're going to spend a pile of money to prove that they didn't infringe it. I personally, I think it's infringement. If she, and this is probably a factor that the court will look at in depth was, if you listen to an earlier episode where I talked about Jesse Ventura and his rights and all that, they're going to look at the facts of, was this part of the consideration that Scarlett entered into when she signed the deal? And by all accounts, it is and was that she signed this particular deal because she got more money based on theater release and theater money, not just, back end sort of stuff. So I'm going to take less money up front so that I can get more money on the back end because of theater stuff. And then when they stream it, and if that's not accounted for, it's accounted for differently. So instead of having a family of 5 at $15 a piece or whatever it costs now, you can stream it for 25 or $30. She lost out on money. So I think she's probably in the right. Whether or not she wins, Well, that remains to be seen.
That was kind of my question regarding, because I was like, I know they can, because you're already seen Disney be kind of being on the defensive, talking about, but then I was wondering too, just I know kind of ties in a little more, like you got HBO Max and everything, they're having these releases at the same time. So I was just curious to pick your brain on that, because I was like, it seems like something that Hollywood is not going to be very much of a fan of.
Yeah, and that will definitely be dealt with in contracts moving forward, and probably already is, that it's being defined. You know, there were a lot of in the older WWE contracts, that sort of thing wasn't covered. Now it's all very much covered, streaming and all of that. I think that if somebody wants to take on WWE about the streaming, I think they can win. But again, WWE is going to spend every dime they have to not lose that case. And it's, I've had clients approach me about this, about, hey, can we take them on? Let's take them on. Well, you could take them on and have a class action lawsuit and try to get a class of people. But that takes a lot of work, and you have to be a certified class. And there's a whole lot that goes into that doesn't matter. But the real issue is the way the royalties get paid out on DVDs was kind of based on where you were on the card and, you know, what portion of the show you're on. So if we're talking about, hey, they got $4 billion from NBC, well, that's $4 billion for 20,000 hours of content that had any number of people on the shows. Now, presumably you can track, okay, did they watch WrestleMania, 14, and they only watched the Chris Jericho match, or they only watched the Bill Goldberg match, or, whoever it is, whatever it was, so that you can kind of pull that out. Okay, of the 1.5 million hours of stuff that was streamed, 0.1% of whatever, was B. Brian Blair. Well, so he gets 0.1% of the $4 billion, but it's not just $4 billion, because those things were broken down. It was like half, whatever. So now you're talking about $4 billion. Now it's 2. And now you've got to portion that 2 to what can be attributed to that particular person. That's a very difficult calculation. Now, it doesn't mean it's not worth doing, but if you're going to spend millions and millions of dollars to win a couple $100,000, is it worth it? That's where a class action could help you. I think that WWE could be beaten, but practically speaking, legally they could be beaten. Practically speaking, I don't know that anybody could take them down.
I was just curious about that, because I was like, there's so many of them. You see so many of the past wrestlers, and you see like their estates and stuff. Like, is there any way they could? I guess maybe if they were ever a union, right? Down the road, maybe that would be the only way. But till then, it's just class action.
Yeah, and okay. I think you asked, or somebody asked about, it was you, about the residuals and things like that. It's all a very different world because of unions, right? Those are union negotiated contracts. That's something that's all been set up and collectively bargained and whatever. That's not what wrestlers are. So yeah, TV folks and writers and actors and whatever get that sort of thing, but that's because it's been collectively bargained with the studios, and the studios agreed to it based on the union representation. So were wrestlers to unionize? Yeah, I mean, that's conceivable that it would happen. Short of that, or short of them being able to join SAG or AFTRA or one of these, it's not going to happen. They won't get residuals.
All right. Well, thank you so much for answering my questions, Mike, and taking the time to be with us this evening.
Yeah, happy to.
We had Jared Wise, couldn't make the Zoom, but wanted to make sure you got a question in, and a couple of you that are joining us passed it on, so thank you for that. He says, Gimmick Attorney, what about Miz and Morrison calling themselves America's Most Wanted? I'm sure James Storm and Chris Harris are none too thrilled.
Yeah, it's all based on prior use, and they are second to use. So it could potentially become a problem if they want to make it a problem. And WWE really wouldn't have much of a leg to stand on, quite frankly, and quite honestly. It made some news recently that the WWE had filed for and protected the trademark, The Collective. And if anybody here is a GCW fan, that's their WrestleMania every year, right? They've got a big weekend show, weekend shows, a big weekend extravaganza called The Collective, and it's been called The Collective for a while. So I represent GCW and reached out to the Fed and said, hey, what's going on here? We clearly came first, and this is our version of WrestleMania. Why would you file this and think they can move forward? And they abandoned it. So again, they're not unreasonable. I just think they didn't do their due diligence, or GCW is so far under their radar. They just didn't care. So America's Most Wanted, if James Storm wanted to make a deal out of it, probably could.
Doug, did you have a follow-up question? Or he was out.
Yeah, I did.
Oh, there you are, bud.
Yeah. So basically, my question is, if you could give new talent, just get into the business on the indies, one piece of advice, what would it be?
Speaking somewhat selfishly, protect your IP, right? Own it. And because you don't know when or if you're going to get famous, and when and if you do, you will get a better deal going to the next place because you own your own IP and you don't have to rebrand. For a lot of those folks, the cost is pretty prohibitive. If you're making $50 and 2 hot dogs to wrestle, you're not, spending $1,000 or $1,500 or, however much, depending on what they want to protect it is, can be difficult, can be very difficult. But at least that way they control their own name and nobody can take it away. One thing I haven't mentioned is something that WWE does in their contracts is if you come from somewhere else and they let you use your old name, so they don't rebrand you, they have the right to file on your behalf, but in their name for your trademark. So, Casio Kid, let's say Matt gets into wrestling and he decides to go, well, he's been Casio Kid forever and ever. And he comes in, they say, all right, we're going to file and protect Casio Kid. They would do it and they would file it in the name of WWE. And then a year down the road, they fire him. They still own that registration. So he has to go back to them and say, hey, you need to give those back. You need to assign it back. And I've had plenty of success doing that, getting it back for people, but they could be difficult about it. And then what? Now you're fighting the monster again. So it's a very interesting thing I think they do in their contracts that allow them to protect somebody else's IP in their own name, but they do it. It happens.
All right. Thank you very much.
Anybody got anything else that I missed? Anybody want to chime in on anything? Nice. How about that? You handled them, Dockins.
Somebody saying something? Did we lose somebody?
I just want to thank Mr. Dockins for being here tonight. This was 10 times better than I thought it would be, more entertaining than I thought it would be. Thank you, sir.
Well, I appreciate that very much. Thanks for being here. Thanks all of you for being here.
We live off a low bar. Okay, we set the bar low, and then we smash it.
Under promise and over deliver.
That is it.
Mike, who's your favorite football team, and why is it the Patriots?
Oh yeah.
Oh boy. I made a realization. It's funny you bring that up. I made a realization last night watching the Hall of Fame induction of Peyton Manning, and it's tough for me to admit, but it's the truth that all my hate for Tom Brady was because of success, not because of talent. He's an extremely talented guy. By all accounts, he's a nice guy and a good person. He takes a lot more shit than he probably deserves, but it's because they were always in the way of my beloved Colts, but he seems like a straight up dude, and to show up to support his rival, and Peyton will do the same when Brady is inevitably put in the Hall of Fame. Was pretty cool.
Oh, dude, come on.
It was pretty cool. I mean, I still hate the Pats, but that's, because they were always in our way. So I will always hate them because of that.
Dockins, you should get you one of these, man.
Oh, you mean the one that's up? I pull it down off the wall, but
you should get you one of these.
Far out of reach.
This is why we hate the Pats. This, son.
What is that? What the hell is that, Casio? Come on.
Come on. Me and Doc. We're the Colts fans.
You're gonna force
the one Super Bowl you had in your life, because freaking who the hell was that guy? Oh, I went to school with my kids. Riche Caldwell couldn't make a catch in the freaking end zone.
The champ rings a ring. We'll take any. Oh, yeah, Dawkins bringing it. Yeah,
all right.
Matching belts. That's how we roll.
I was at that AFC Championship game. I've been a Colts season ticket holder for 15 years or so now. I was at that game, and there were some Patriots fans sitting right in front of us. And when y'all went up 18-3 or whatever it was, man, they were giving a shit. And we had to take it, right? I'm like, I've seen this before. We're gonna blow it to the Patriots again in the championship game. This is just how this goes. And they took great delight in the fumble that resulted in a touchdown by a lineman on the Patriots, and gave us all kinds of hell. Well, in the second half, Jeff Saturday scored a touchdown from the same thing. Edge wasn't with the team. Joseph Adai, I think, fumbled it or a bad handoff, and Saturday fell on the end zone. And man, I did not let them live that down. I just
rivalry. Awesome freaking rivalry. Love it.
It was a lot of fun. Those were the best games to go to because the stadium was always electric. It was always so much fun.
Sad it was one-sided.
Yeah, I mean they played. What would they say? They played. Manning and Brady played 17 times, and Tom won 11.
Yeah, 11-6.
Yeah, that's one-sided.
It's very one-sided. But I'm like Dockins. As soon as Tom moved to Tampa, I had zero problems with him.
Yeah,
I was like, cool. I hope he wins one with Tampa.
Why the hate for Boston? My God, guys, come on.
They're easy to hate.
Fuck the hoodie. It's easy to hate the hoodie. He's obnoxious. He's just a jerk.
You hate us because you hate us. Woo! Go Pats!
Amen, Anthony.
By the way, Dawkins, James has just announced that he is, if you can't see him, he's dressed up as a gimmick attorney for this evening's festivities.
Oh, because the bow tie. I like it.
Yeah, in honor of a real gimmick attorney, I decided to dress up as a gimmick attorney, So just wanted to show some love, good to see you, this time over screen, but can't wait to see you again in person in Chi-Town. But hey, good to be here, show some love. Casio, my first Zoom with you, so good to see you, buddy.
Pleasure, man. Thank you, everybody, for joining us. Thank you, James, Doug, Lindsay, Tim, Rob, Anthony, Eddie, Ryan, Mike's over there, Matt. I know Amy was here earlier, AJ, Andrew, saw you tweet about, he called it Night Court. I think that should be the name of this episode, is Night Court, brother. But thanks, everybody, for stopping in. Thank you, Lauren. And thank you, Dawkins, man. We appreciate you answering all these questions and doing all the big words like Pop Torts and per se and stuff like that.
Well, happy to do it. I'm scrolling through the questions. There were some that wasn't able to get to. Like people were asking about Jerry McDevitt. He's their outside counsel, not inside counsel. He's at a huge firm, and he's still associated with the company. So he still does the stuff for outside work. The Chelsea thing was done by inside counsel. They're not going to pay McDevitt's firm's fees for something like that. So it wasn't him. I've talked to him. He's a good guy, easy to talk to, very good attorney. Got no hate or bad things to say. And I've been opposite Jerry on things, and which is fine. You can do it in a respectful way because it's business at the end of the day. And he's getting older though, so I can't imagine he's going to be involved too much longer. His firm, I'm sure, will be, but he's sooner than later will step away. But he's made a lot of money because of his relationship with Vince and with the company. So God bless him.
So hey, Mike, real quick.
Yeah,
I didn't ask a question, but I want to. What is the going rate? Like I know divorce attorneys and civil stuff, X amount. Like what is the going rate for these type of fees for attorneys?
It all depends on the firm, the size of the firm, and where you're located. So my firm, for example, we're in Detroit, Toledo, Charlotte, Tampa, Sarasota, Charleston. Well, I'm missing some of our smaller offices, but we're in a lot of offices, but we very much have Midwest rates, and it's kind of the 75 corridor. So we are able to, and we're happy to be where we are. We don't want to grow. We've got 270 lawyers, something like that. We don't necessarily want to get any bigger because you get bigger and it just becomes a different set of problems, right? It's 270 in 7-8 different offices is easier to put your hands around. But when you become like McDevitt's firm and you've got 1,000, 1,500, very different, and the overhead's very different. So we're able to pitch, hey, look, we're an AmLaw, which is a ranking system. We're an AmLaw 200 firm. We're in the top 200 firms in the country based on revenue. So you get smart people, you get talented people, but we don't have to charge New York rates, Atlanta rates, California rates. So it all depends on where that is. But even within my own city, there are certainly people at smaller firms or solo practitioners that will have much lower rates than the attorneys at my office, but they don't have manpower, right? If it's a solo practitioner, it's basically going to be them. They might have a paralegal, they might have an assistant, but that's it. Whereas for my firm, when I get people who call me and say, hey, I need some help with this IP thing. Oh, and by the way, we're getting sued. okay, well, I'll get somebody from the litigation group, and
Yep.
we've got associates, and we're an engine that can run. So there's no hard pressed number. There's no really anything to be able to tell you. It's all going to be based on reputation. And sometimes firms will charge unbelievable amounts of money, and they're shitty lawyers, and they're just not very good, but it's on reputation.
Okay, so with that being said, like I have a divorce attorney, 250. He's like, hey, I got capitally, like for I got certified for capital punishment, right? He's like, hey, I'm gonna start charging 500. With that being said, what does McDivitt like? What is their numbers? Are they like 1,000 an hour or more?
I mean, it's based out
give
of
or take
Pittsburgh.
ballpark.
It's
Yeah.
based out of Pittsburgh, so I doubt he would be that high, but he can't be any less than $750, $800. He might be up to 1,000, but at his level, at that size firm, how hands-on he is probably pretty limited. So he's got one of his junior partners or associates doing it, but they're still coming in at, $450, $500, $600 an hour, but they can put more time and attention into it than he can. And so they'll do whatever they have to do and bring it to him, and he blesses it. And because he's higher, think of it like a pyramid. That's ideally how a law firm is, not a pyramid scheme, but it is a pyramid where your top earners and your top partners are up here, and you've got all these other people down here that are making less money because they get less of a percentage of what they're doing, but they're kicking that excess money up. So ideally, you've got the bottom being big enough where they're covering the overhead of the firm. So they're covering your lease and your copy machines and all that kind of stuff. And then anything extra goes to those partners that are above them. Firm like mine, we're more like a square. We're not there. That's very difficult to get here, because to get here, you honestly don't like people. You don't care about your people, because you will burn and churn your young associates and not let them ever become partners. So they leave the firm, join somewhere else, and you get new people in at the bottom.
So does that mean you guys have kind of a flat rate that kind of goes along with everyone that's involved?
It's not really. It's all kind of based on what you do. Intellectual property lawyers bill differently than med mal lawyers, bill differently than litigators and all of that. And to an extent, what you bill almost doesn't matter, or how many hours you bill, because you're going to write it up or down anyway. Right. So if you tell a client, I think this litigation, to file, it's going to cost $15,000, and you spend 25, you're probably going to write off that 10 grand. You just be a better estimator, and you're going to write that time away. And so it doesn't matter what your rate is.
But do you think that is your company's philosophy, or is that common?
That's everywhere. That's everywhere. The bigger firms you are, a lot of big companies will only want big firms representing them. Back before my firm merged into Shoemaker, where I am now, we were just a small, only intellectual property law firm. And we would go and we would invariably make it to the finals and be the last couple of firms that were going to get picked by some, Fortune 500 or Fortune 100 companies. And they would call us and say, hey, we didn't pick you. Sorry. We didn't pick you because we didn't think you're qualified or good. We loved you. We think you're qualified. We think you do great work. But I work for a general counsel, or I work for the chairman of the board. And if something goes sideways for some reason, and he says, well, who the hell is this little firm in Perrysburg, Ohio? Why did you hire them when you could have had these guys out of Atlanta? Strictly because they had a big name, strictly because they had a big reputation, but you also had big bills out of it. So now that I'm with the firm that I'm with, we can now throw around some weight, but still offer, hey, we're still cheaper than the New York firms and the LA firms.
Awesome. Thanks, man. Appreciate it.
Yeah, for sure. Thanks for being here.
So if I'm CM Chunk and I come up to you and say, I want to copyright my name, do you, are you giving me, hey, here's what's my rate going to be? Is that based off how much time you think you're going to have to put into it? Or every trademark, every guy that comes in here and asks for that, I just give them the same rate?
Yeah, same thing. A lot of, almost all things trademark related and patent related and copyright related, it's all flat fee. So it's going to cost.
If you happen to work
X.
on mine more than last guys, it's all going to even out because you're doing it across the board. That's what,
correct.
That's what
yeah, everybody gets the same number.
Whatever rate you give them.
Yep. Now sometimes we'll give volume discounts, so you get a big client who's got a huge portfolio, and like, well, we're not going to pay that. Give us your best number. Like, okay, I'm going to get this volume, so of course I can manage that down a little bit. but it's based on volume.
So are we recording still?
Yeah.
Okay.
I'm still rocking the show. Do you want to go? Do you want to ask something off the air?
Yeah, I don't ask numbers on recording.
Okay. Yeah, we'll sign it. Anybody else want to get anything in on the record? Per se? No, we're done, per se. All right, seriously, we said it again. Thanks, everybody. Rob? Somebody said Rob's got a question?
Yeah, I got a
what's up,
question. Mike, do you have a favorite court case? Like just a famous one that, you really like or whatnot?
There's the one I probably talk about
And
more.
please let a Netflix documentary be on it.
Not yet. Not that I know of. In law school, I would have people that would come to me and say a court case name, and be like, oh, this case. I'm like, that means nothing to me. I don't give a shit about a court case name. But the one that I've talked about the most, I couldn't tell you the caption, right? I couldn't tell you who the parties were, but the McDonald's coffee one. That people always just get sideways about. Well, of course it's hot and they got burnt. Like, how stupid do you have to be? And they got $10 million or whatever. And that is one of the most misunderstood cases that people, the armchair lawyers of the world like to cite. And we learned about it. I want to say it was like the first week of law school in our torts class. But I'll jump to the end first. The court awarded, maybe the jury, it might have been a jury case, awarded this lady a certain amount of money. Well, the judge has the ability, it's called additor or remitter, where they can add money to a damages award or remove it. And they say, yeah, the jury was right and they made a right decision, but they awarded way too much money. It doesn't happen often, but in this case, the judge said that's way too much money for this and cut it in half. I want to say she got awarded like 450 grand, 400 grand, and it ended up being like $2. But the case, what people don't understand is what it was really based on. And it was based on something called products liability. And the products liability is strict liability. So kind of like when you hear about strict liability, unfortunately, most of the time you hear about it, talking about it in a statutory rape case. So when somebody gets charged with statutory rape, the circumstances can be that, it was a kid who was 18. This actually happened to somebody. He wasn't in my class in law school. He was a couple years younger, but he was a black guy and he started dating a white girl. And they had sex, and he was 18 and she was 16 or 15 or whatever. So legal consent was within a certain age range, but the dad didn't like that it was a black guy. So he got hit with statutory rape. Well, it's strict liability. Either it happened or it didn't. And if it did happen, you're going to get charged. You're going to get hit with whatever punishment that the courts are going to give you. Right. And so he was technically a rapist, but it wasn't really rape. Right. Once everybody found out kind of what the circumstances were like, well, this is bullshit. But it's product liability, it's strict liability. That is to say that a product was so unreasonably unsafe that you're going to be held responsible for it, person who made it, and you're going to pay damages. So think about like a lawnmower and you don't put the guards on the deck, right? It's just blades out there spinning. But of course somebody's going to lose a toe or foot or get hurt or killed or something's going to fly off, right? That's unreasonably unsafe. Well, the story with the McDonald's coffee was McDonald's had done surveys and people like their coffee more than Burger King coffee and Dunkin' Donuts coffee and whatever, because it was hot and it was hotter than those coffees. And so what McDonald's did was jack the hell up on the temperature of the coffee. So if a safe temperature is 120, they made it like 145 and 150. Well, the difference between, I got this coffee and I dropped it in my lap and, getting burned was you would have some time period, 15 seconds, 30 seconds, something like this for a normal temperature coffee to be able to get up, pull your pants off, whatever it might be, and not get burned. Well, they had it so hot that you had no time to be able to do that. It was almost instantaneous. And she got second and third degree burns on her inner thighs and on her lap area. And so what the court said was, you knew it was too hot. You knew it was dangerously too hot, and it was unreasonably dangerously too hot. And because of the product's liability issue, and it was so unreasonable, and they found it to be unreasonably unsafe, that's why she got paid for it. It wasn't because it was hot coffee. Of course it was hot. It was that it was so much hotter than everybody else's that it was unreasonably dangerous. So that's one of my favorite cases to talk about.
All right. Thank you. Is there a recent court case that has drawn your attention?
The Bill Nye and Disney one, really, because that has potential practical applications in my real life for my real life clients.
Right.
And unfortunately, it was kind of a lower state court in Florida. So it wasn't like it was the Supreme Court saying it, because that would be something entirely different. So what happens is when you sue WWE, for example, you have to sue them up in Connecticut and up in I think that's the Second Circuit. You have to sue them up in the Second Circuit. So what the courts will look at is, did this circuit, and this is federal law or potentially state law, but they'll look at what has our court decided? What have we, as a circuit of 3, 4, 5 states, whatever it's in that circuit, how have we decided similar cases? Oh, we haven't decided. It's a matter of first impression. Then they kind of start looking at, outside of federal law, what did the states do? And then outside of that, they'll say, well, has anybody else in the country ever dealt with this? And do we agree with it? So it's not binding precedent. So because it's a lower level sort of state Florida thing, it's not necessarily binding to Connecticut. And because WWE has such a huge presence, and Linda McMahon has such a huge presence, you might be fighting an unknown defender up there, right? That's going to protect the company, which is why they make sure that you have to fight them there.
All right. Well, thank you for your time.
Yeah, for sure. Thanks for being here.
It's been great. Thank you.
Appreciate it.
Thanks, Rob. Doc, I don't know if you saw today, did you see the lady that sued McDonald's and blamed them for making her break Lent?
Oh, no.
She said she hadn't eaten in a month, Ksenia Ovchinnikova, and she said she saw an ad for the burger. It made her cave in and eat and break Lent. She is now seeking 100 rubles, which is 14 American dollars, but she has sued them for sustained moral damage.
What country did this happen in?
Russia.
I mean, Russia's anything goes there, right? Who knows?
But I mean, it sounds kind of silly, but it could also open up so many doors if you can sue and blame an ad for making you do something with consequence.
Well, people have tried that, right? That their food is addictive and they're obese because of it. And that's gotten nowhere because it's silly. But if food were found to be, think about, if any of you guys remember this, Olean or Olestra, the artificial fat that they were making chips out of, right? They could say they were fat free because that was in it. And that was causing people to have explosive diarrhea. And you don't really see that stuff in those fat-free chips anymore because it was causing such gastrointestinal issues. It didn't do it to everybody, but it did it to enough people that they weren't selling very well and they were starting to have issues. So if McDonald's had something like that they added something to their food, sure, that could cause problems, but
she's blaming the interesting is $14. It's almost like we just want to test the waters for maybe a bigger case or something. Seems weird. I mean, it could be just publicity stunt,
an attention grab, right?
We go to her Instagram and she's trying to be a model, but it is very interesting.
It's Russia and it's against an American company, so there's very much could be some political stuff behind that, right? Like we want to embarrass the American company,
biggest chain.
Yeah, damn Americans, let's get them out of here, kind of thing.
Sounds silly fodder, but it might be interesting to keep up with and see what happens with it. So.
Yeah, I'm gonna look into it when we get done.
Thanks everybody for joining us. I hopefully we'll do this again sometime. We appreciate you being a part of the AFS family. Always fun with these little family reunions, and had a blast with all of you top guys and top gals. Absolute fun. Dockins, thank you for your time, brother. We appreciate it.
Looking forward to seeing everybody
joining us. Thank you, Lauren, for helping us out.
Thanks,
I am
Lauren.
Casio. Everybody, thank you. Stay mashed.